Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. This will be a little bit of a bittersweet video because although I'm going to be very, very happy, almost as happy as all of you, to see the pistol brace rule finally die the death it deserved, there is nothing that the ATF has ever done that probably gave Washington Gun Law more material to work with than the pistol brace rule. But as some of you may have heard late last week when we were out in Illinois, the pistol brace rule has officially come to an end, not a moment too soon. We'll explain what happened, we'll explain what it means to you, and we'll explain what it means moving forward. So today, let's spend a few minutes and let's talk about writing the obituary for the pistol brace rule. Okay, America, we are talking about the pistol brace rule, one of the very first things we ever talked about when we kicked around the idea of doing a YouTube channel called Washington Gun Law. We were talking about the Form 4999, which it was kicking around at the time, and all the scoring criteria and points you could accumulate. Then ultimately we got the final rule, which resembled nothing of what we had commented on. The lawsuits started dropping, and literally every single court that got their hands on any kind of legal challenge to the pistol brace rule, we didn't even get into the constitutional issues of it. No, we stopped right at the Administrative Procedures Act because, shockingly, executive agencies only have the authority to regulate the stuff that Congress delegated them that authority, and getting to redefine what a short barrel rifle is, shockingly, is not ATF's job. It belongs to Congress. And so the pistol brace rule began to crumble and crumble mightily. And as a matter of fact, there really was no court that was ever given it a thumbs up. The final case was a case that we called Mock v. Garland. It's now called Mock v. Bondi. This was one of the cases, many challenges. This one was brought to us by our good friends over at the Firearms Policy Coalition. Now, you may recall this case because the Fifth Circuit had already vacated this rule and the Department of Justice was kicking around appealing it, recognizing that the United States Supreme Court would likely, if they took the case, and that's a huge if, but if they took the case, likely affirm what the Fifth Circuit has done. The Firearms Policy Coalition and the United States Department of Justice have agreed to a settlement of this lawsuit. And this, of course, will bring an end to one of the saddest chapters in the history of the ATF, a book which has multitudes of very, very sad chapters. But this, as you recall, the pistol brace had always been okayed by the ATF, had always been considered not to be a short barrel rifle, had multiple occasions. They had actually made statements to that effect. And then one day you woke up and the Biden administration was like, well, we're going to rethink that policy. And then all of a sudden they publish a rule that basically says, well, yeah, all of those brace pistols that you guys got, yeah, they're actually unregistered NFA items. And that began the scurry of what many of you were worried about, as potential confiscation and things like that. None of that ever came to fruition. As it turned out, it was a gigantic headache over a big fat nothing burger. But FPC President Brandon Combs, in speaking on behalf of its members and this settlement agreement, very correctly states, the dismissal of this appeal should be the final nail in the coffin of this unconstitutional Biden ATF assault on gun owners. As we explained in the case filings, brace pistols are not short barrel rifles. But either way, they are unquestionably arms protected under the Second Amendment. We are thrilled to have secured this important win for liberty and excited to take on even more unconstitutional laws so you can exercise your rights when, where, and how you choose. Other representatives from Firearms Policy Coalition were quoted as saying, the government is finally retreating from the Biden administration's patently unlawful effort to turn millions of peaceable people into felons by decree. This horrible rule was a perversion of our system of limited government, so we're glad to see this case resolved in favor of liberty and the rule of law. Now, this is one of about 6 or 7 lawsuits, all of which were equally as successful to various levels in challenging the lawfulness of the pistol brace rule. And remember, this was never about a constitutional challenge. All of these successful challenges came from the Administrative Procedures Act, a piece of legislation drafted and passed in 1946. But this should be, for the time being, and hopefully forever, the final video that Washington gun law ever does about the pistol brace rule. And while I sit here and ramble on for a moment, I want to just go back through memory lane to all of the wonderful experiences we had and all the wonderful opportunities we had to grow our audience and grow our platform, thanks all in part to the horrific acts of the Bureau of Alcohol, Tobacco, and Firearms. And for that, ATF, we will forever be indebted to you. Okay, listen, we'll go ahead and link up everything you need to know to understand the final death of ATF's pistol brace rule, not a moment too soon. If you got any questions about this or anything else related to what's left of our Second Amendment right, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, cool. Click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.
Therein lies why we say in the legal defense sector that we are the most value-centered, cost-effective legal defense in the space, and we are. There's no question. Now, again, I've said before, we've got great competitors out there. They have outstanding products. We admire them. They paved the way for us. You know, we analyze the folks out there that are doing the same thing we're doing, and we took some great ideas from them, and we went down a path of believing that we were going to do it with a service aspect, a servant's heart, and we have again. Our number one goal has been to serve others first in a way that the industry hasn't seen.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.